Good afternoon. Welcome to an oral argument session of the 6th District Court of Appeal. We have one case on our docket today. It's Grand Vista of Orlando Condominium Association and Marriott Resorts Hospitality Corporation versus Rick Singh as property appraiser, Scott Randolph as tax collector, and Leon Brudzinski as executive director of the Department of Revenue. And the number for the case is 23-3618. As you heard, my name is Judge Mary Nardella. I'm joined today by Judge Mize and Judge Ganim. We afford 20 minutes per side for argument. Counsel for appellant, would you like to reserve any time?
Yes, 5 minutes.
I believe we're being broadcast today, but I do know they were struggling with that. So anticipate that this will be broadcast, but that may not happen today. Counsel for appellant, whenever you're ready, you may come up and begin your argument.
May it please the court. My name is Lauren Purdy with the Gunster Law Firm. With me at counsel table is my colleague Amy Mish, and in the gallery is my law partner, Ron Nunez. Together we represent the appellants. The issue in this appeal is OCPA's disregard of the plain language of section 192.037, which provides the legislature's instruction for how property appraisers must calculate ad valorem taxes for timeshare property. And the trial court's judgment approving of OCPA's assessment should be reversed for two basic reasons. The first reason is a pure question of statutory interpretation. It's very straightforward despite a 6-day bench trial. And that is, under section 192.037 subsection 11, if there is an inadequate number of resales, OCPA is required by the legislature to take, quote, the original purchase price of the Grand Vista deeded weeks and subtract from that price certain fees and costs of sale that are specifically listed in the statute. It's not disputed that they didn't take the original purchase price of the Grand Vista.
Counsel, can I stop you there and ask you a question I know you're ready for? It seems to me that in your initial brief, you take the position that because it's delegated to the legislature can define or determine any methodology they wish. And that could be inaccurate, and I want you to set me straight if it is. Is there a statutory scheme for determining fair market value that the legislature could enact that would not comport with Florida's constitutional mandate of a just valuation for all property?
I suppose it's theoretically possible, Judge Nardella. In this case, we don't need to worry about. There's also the deference to the legislature that their judgment is appropriate. The Sunset Harbor decision from the Florida Supreme Court recognized that the legislature is who is vested with the power to try to determine just value.
They're vested with the power to try to give a methodology for determining just value, which is fair market value. Mm-hmm. If they then do that by saying something that is just clearly not fair market value, like if they had just said, oh, if by default, if there's no good way to determine fair market value, all property is $100,000, right? You would say the legislature, yes, they have the authority to determine the methodology for determining fair market value, but it must be a methodology for determining fair market value. They can't just completely choose something that has nothing to do with fair market value, right?
Yes, I would agree. Now, I think one thing that's important before we go further is there is no dispute here that the statute that was enacted in 1988 is constitutional. There's been no challenge by the property appraiser that the plain language in the statute as written is not comportment with fair market value. They simply don't want to use the plain language in the statute requiring the use of the
Counsel, can we
original
talk
price.
about that? Because that is a concern that I have, is what is the argument being presented to us on appeal? And it seems to me that it's very close to, if not the same as, and I want to hear your perspective on an as-applied constitutional challenge. So they frame it as in your statutory interpretation. They frame it as a statutory interpretation method. If I go with your interpretation, it doesn't, it's unconstitutional, and therefore I should always strive for a constitutional meaning. That seems very close to an as-applied challenge. And if you could tell me why you don't think it is and what they've missed and what maybe due process problems that would present, I would.
I think there's a couple answers to that question, Judge Nardella. First, in the trial court below, they did not suggest that the statute's unconstitutional. They have one way of reading it. They don't like our way of reading it. That's not the same thing as saying that the statute is unconstitutional. There's basically a dispute over whether the original purchase price means what it says. So our position would be any as-applied challenge, which they haven't raised in their briefs, they didn't raise in the trial court, is completely unpreserved and not something that this court can consider on appeal.
If we were to disagree with you on that and find that they have effectively made an as-applied challenge, would that pose problems for you in terms of the original purchase price prong of the statute? Because that's clearly not the current fair market value. I mean, the statute's been in the books for forever, right? So say there's never really a good resale market for timeshare units because they typically decline in value and people don't want to buy them, right? So there's just, we're in the year 2400. There's still no resale market. Original purchase price, 1997. Can anybody say that that is fair market value or even an attempt to get at fair market value?
I think you'd have to look at the evidence that's presented to the trial court to know if it is an appropriate approximation for fair market value, Judge Mize.
Well, no, but that, I mean, I guess you could determine whether the original purchase price was, as a matter of fact, today tied to fair market value, but as a method, just by coincidence, but as a methodology, right? When the legislature is required to give a methodology to determine the value as of January 1st of each year, the just value, which is the fair market value, is saying we're going to pick a value that is in no way tied to that year. Is that a fair methodology or a legitimate methodology that the legislature can use to fulfill its obligation to determine the value in that year? Something that is by definition tied to a different year?
Well, potentially. I think that would ultimately be potentially a mixed question of law and fact if we're talking about the universe where it's 2400, right? We're talking about here a property that the last original sale was only 7 years before the assessment that we're talking about. And the concept that the property appraiser can not really, we would say under subsection 10, actually fulfill its obligations under the professional accepted appraisal practices, actually assess the resale market. They didn't, to your point, Judge Mize, they didn't even try to verify a single resale in the Grand Vista property in 2017. They did it in years past.
I get your argument on that, but I'm talking about your backup argument, right? Assume that we find that the trial judge did not err, at least there's competent substantial evidence for there was no resale market. And so we're at your second argument, which is the original purchase price. The legislature, the methodology gives, was by definition not tied to the year that the property is being valued in.
Yes.
So how can that be a methodology that determines the value in the year the property is being valued when it's by definition tied to something years before?
Judge Mize, I think there's a couple answers to that question. And first, the court could look to the observations that the Florida Supreme Court and the Fourth DCA made in the Oyster Point and the Spanish River cases about how the timeshare market works, and the legislature's decision immediately after those decisions came out to enact the statutory scheme that it did. It's understanding eventually there will be some form of a resale market. You're required in step 1 of every year to assess anew whether the resale market is now providing an adequate number, not the same as a developer market, an adequate number of resales to fairly value a timeshare property. Only if you decide in that given year that there is not an adequate resale market do you fall to the backup, which says you presumptively at least start with the original purchase price and subtract from that.
Why is that okay, right? Like, I get it, why it might be a good idea, and the rationale seems to be, listen, sometimes there's just no better option, right? Like, what were they supposed to do? Problem is they're cabined by this language in the Constitution that says you've got to value the property year by year. Right? Like, I think if you agree, if they said, all right, if you can't get a value for that property, pick a completely different piece of property in a different county or a different state. You'd say, no, that's not a methodology to value this piece of property. That's a methodology to value a completely different piece of property. That's not constitutional, right? So here, it's a little more specific, but you have to value the property in that year, and they give a methodology that on its face, by definition, goes to a different year. Why is that a legitimate exercise of the legislature's authority when it, on its face, does something different than what the Constitution says they can do and must do.
But I think, Judge Mines, again, there's 2 points to that. One, we don't know if ultimately the methodology isn't consistent with what fair value is without a factual determination. So I
So you're
think,
saying, well, by coincidence, they might be the same in both years, and if it is, that'd be okay?
Judge Mines, I understand that part of Judge Nardella's point is there some sort of as-applied challenge here? In any given year, it could be a totally appropriate methodology. And I take your point that 100 years from now, could we still be in the same feedback loop? And the answer would be the redress for that is to go to the legislature to change it, or bring an appropriate preserved constitutional challenge to the plain language of the statute as it is written, which was not preserved in this case, was not raised in the trial court, has not been appropriately raised on appeal. So I think the best answer I can give to that question, Judge Mines, at a minimum, we don't know if the methodology in any given year is appropriate without a factual determination.
Well, we don't know if it is likely to have a starkly different value, as a matter of fact. We do know that by its very definition, it is going after a year other than the year mandated by the Constitution, right?
Yes.
Well, I
But
would say something different, and I think it's your point, and I take well your other point. Fair market value is never static, right? It's a time and it's a place, and it's legally synonymous with just valuation. Original is static. I mean, they're just,
it is static, although, Judge Nardella, one thing to keep in mind about the way the sale of timeshare units works, which is maybe a little bit counterintuitive or a little different than something we're all used to. We're talking about 46,800 individual units. There's 900 units on the property times 52 years, almost 50,000 interests that were sold over the course, the original sales over the course of many years, stretching out over many years. Whether or not ultimately that static for that one little sliver of interest is static doesn't necessarily tell you whether the overall valuation of a timeshare property that, again, the last resales were only 7 years later.
right. And that's
is
a good
actually-
point in your case. I guess my point was, would you concede if we were looking 100 years? 100 years from now, we were looking at the original purchase price as set by the statute, that statute as applied would have a problem?
I would, as applied, could have a problem, which is, I think, my point about you need to have evidence in the record to help to support that it couldn't be an appropriate way of valuing it in a just manner. So it could be, but again, because that wasn't preserved or raised here, we don't think that that issue is before the court.
Ms. Purdy, I want to maybe add to this discussion. It seems like both sides agree that both 192.037, the fee timeshare statute, and 193.011, the assessment statute, apply. If your interpretation of 037 is correct, and we have to revert to the original purchase price minus those, those high costs of marketing, et cetera, does the property appraiser still have the discretion to apply the 8 factors in 193.011, provided there are facts to support any of those, to make an adjustment to that value, which, and if so, would that solve the timing problem, perhaps, that we've been discussing?
Yes, Judge Ganim, exactly. All of the factors in 193.011 except subsection 8, which is the usual reasonable fees and costs, in the context of non-timeshare property. Obviously, that particular provision is different between timeshare and non-timeshare, but yes, exactly. You're still required by the 8 factors to consider and to make additional adjustments for the value of a property based on where it's located, what it's been sold for, all of the different factors to the extent they apply in the context of a timeshare property. So in looking at the statute as a whole, in looking at the requirements for professionally accepted appraisal practices and all of the requirements in what I kind of call the general ad valorem tax statute 193.011, you certainly can still get to the fair market value, even if you have to get to subsection 11. Just briefly, I think the court understands my point about what the original purchase price means. To expand on it just further, certainly the is modifying original purchase price. It doesn't mean an original price of some other product that's sold in 2017. It's clearly intended to refer back to the units at the property that's being assessed in this case. We can also look to subsection 2 of 192.037, which requires the property appraiser to add up the value, the fair market value of every individual unit to create the final tax bill for the entire property, which the Grand Vista pays on behalf of all unit owners. So the plain language is clear. The property appraiser doesn't like the plain language. We understand that. But there's nothing in the plain text of the statute that allows the property appraiser to use developer sales of the MVC Land Trust as the methodology for calculating taxes for the Grand Vista property. So we pointed out in our briefs, the MVC Land Trust has interests in timeshares from literally New York to Hawaii. Elsewhere in the record, there's interest in Arizona, California, Nevada, New Jersey, Missouri, South Carolina, other places in Florida far from Orange County. You're purchasing points for stays in any of those properties. It's a completely different product. In fact, the MVC Land Trust, as I understand it, doesn't even get a tax bill the way that the Grand Vista property does. It's not even apples to oranges. I don't even know what the analogy would be. So here, based on the plain language in construing not only 192.037 subsection 11, but also 193.011, the court can resolve this case in reverse just based on the plain language and the failure to apply subsection 11 alone. Reserve the remainder of my time.
May it please the court, I'm Ken Hazuri of DSK Law. With me at the council table today on the far side is Amy Mercado, who is the Orange County Property Appraiser, and Anna Torres, who is General Counsel and Deputy Property Appraiser for the office. And I'm going to jump right into subsection 11 because it seems like that's where the focus is. I'd like to point out a factual issue first. These statements that the last sales of deeded weeks in Marriott Grand Vista, the most recent ones, were 7 years before the valuation date. There's no evidence to support that. The date that they're relying on for that is the date that Marriott in general, the Marriott Worldwide Vacations Corporation, switched from offering deeded week products to their trust product. Okay, so the specific sale of Marriott Grand Vista by Maury, the developer, the evidence at trial was that was in the 1990s and 2000s.
Counsel, why does that matter?
Well, it goes to I don't think it should necessarily, but it goes to your question about 100 years. They're trying to get it as closely as possible.
But why does
the
any
date.
of that matter if you did bring an as-applied challenge?
Well, okay.
And
That's the
so,
next
yeah.
issue. Thank you. Because I would submit that this argument and this issue falls under the holding of Planned Parenthood of Southwest and Central Florida versus State at 384 Southern 3rd 67, which sets forth the well-established doctrine that statutes, let me read the whole thing, statutes come clothed with a presumption of constitutionality, and the important part, must be construed whenever possible to affect the constitutional outcome.
Counsel,
So,
do you agree you didn't make an as-applied challenge? You haven't challenged constitutionality?
we did not, Your Honor. I wasn't in the pleadings and wasn't at trial.
All right. So you have the canon that says, when possible, construe them in a way that avoids a constitutional problem.
Correct.
If we just think your reading of the statute is not a reasonable one, and you simply can't construe it that way because it's just so far disconnected from the plain language, the only reasonable way to construe it, at least by far the best way, is the way your opponent asserts. So if we pick their interpretation of the statute, you haven't challenged the constitutionality of the statute, right? Even if their interpretation is unconstitutional, you can see that. Doesn't that mean you lose and we remand to apply the statute as written?
I don't necessarily think so, Your Honor. Excuse me. We are the appellee. We didn't argue it in our briefs either, strict unconstitutionality. I have been in arguments where the courts decide to make their own decisions over and above what the briefs say. So I think you have discretion to solve the problem. But I think the best answer is it should be interpreted in a way that's constitutional, which I can explain
No,
ways to do that.
I'm just saying, assume we think your interpretation is not a reasonable one. Because you at least, that canon, you at least have to have two reasonable interpretations, right? So if you have two reasonable interpretations, one that would render the statute constitutional, one that would render it unconstitutional, the canon says, go with the one that's constitutional, right? Isn't that how the canon works?
Correct.
So I'm saying, assume that I find your interpretation unreasonable, and so that canon doesn't come into play.
Okay.
You're saying that even though you haven't met it, in order for you to win, does that mean we would have to, on our own, decide to take up the constitutionality of the statute, even though you did not bring a constitutional challenge?
I'm not sure about that, Your Honor, because they didn't argue that the statute is unconstitutional as written. So if you,
I know, they want to apply it as written, so they're not asking us
Okay.
to not apply it. Their
Okay, fair
interpretation
enough.
of the statute doesn't require it.
by your hypothetical, as I understand it, you don't accept our interpretation, making it constitutional,
Correct.
right? And as I understand it, because of the question you're saying, because you didn't argue that it was unconstitutional, that would mean that the court would be coming to the conclusion that as written, it is unconstitutional. We just didn't challenge that under your
Well, no, it means
hypothetical.
it means we wouldn't reach the issue of constitutionality, because we would say, neither party has challenged the constitutionality of the statute, nobody notified the Attorney General, right, as they're supposed to when they're challenging the constitutionality of the statute. Therefore, we're not going to decide the constitutionality of the statute. We're just going to say, apply it under the interpretation we think is the best interpretation, the reasonable interpretation, and say the constitutionality for a case in which someone challenges it.
Well, so that would mean, if carrying your question to its logical conclusion, you would be writing an opinion, as you said, remanding the case, so you're saying they win. So you would have to write an opinion explaining how subsection 11, what it means, and the opinion would be putting forth, we would respectfully submit an analysis of subsection 11 that doesn't comport with the Constitution. So then you got a real problem with your case law there if you do that.
No. Anytime that you declare a statute unconstitutional or constitutional, you must first decide what it means, right? So you interpret the statute and you say, here's how we read it. This is what we think the correct reading of it is. And then you say, does this comport with the Constitution, yes or no? And what I'm saying is, since you have not asked us to answer that second question, would the outcome not be, here's the reading of the statute, no one has challenged the constitutionality of that reading, therefore, trial court, apply the reasoning, and we don't decide today whether it's constitutional because no one has brought a constitutional challenge, no one has brought in the Attorney General, right, or notified the Attorney General. Why is that not the outcome?
Okay, so if you land on, you agree that it should be read the way that they say it should be, and you're not going to, and you don't accept our interpretation to make it constitutional, then yeah, I think it would come out the way you described it. I can't think of a different way to say it wouldn't. But we respectfully submit to you that that's not the proper interpretation, and it can be interpreted to be constitutional. You have that canon, and your questions did, I think the word cabin was used, explain how the Constitution cabins the statutes you have to interpret in a manner to reach just value on an annual basis. So we do have that. Now, the other doctrine I would refer us to is the doctrine that's actually set forth in the Reading Law Treatise and in the ERA versus State and Florida Department of Environmental versus Contract Point, all cited in our brief, which says if a part of a statute appears to have a clear meaning if considered alone, but when given that meaning is inconsistent with other parts of the same statute or others in para materia, the court will examine the entire act and those in para materia in order to ascertain the overall legislative intent. Scalia and Garner say laws dealing with the same subject being in para materia should, if possible, be interpreted harmoniously, and the related statutes canon is based upon a realistic assessment of what the legislature ought to have meant and rests on two sound principles: that the body of the law should make sense, I think that bears heavily here, and that it is the responsibility of the courts within the permissible meanings of the text to make it so. So when you take this doctrine, you look at the constitutional requirement of just value on an annual basis, you look at the rest of the statutory scheme, including 192.042, which comes immediately after 192.037, and says you have to value on an annual basis. And when you look at that, I think those two doctrines that we put forth give you the ability to read 192.03711 in the context of the entire act and the statute and the Constitution, and reach the conclusion that what we're really talking about here is developer sales.
Mr. Azari,
Initial developer sales.
I wonder if your argument on this point proves too little in this sense. When I read 192.037.2, which is the fee timeshare real property provision that says you have to aggregate all the individual unit weeks to get your total value, that provision implicates 8 different statutorily defined terms throughout the rest of the statutes dealing with timeshares and property evaluation. And the one I'm most interested in is the definition of fee timeshare real property, which is 192.001.14. And that specifically says that it's property subject to timeshare interests sold as a fee interest in real property. So if I think both sides agree we're operating under 192.037.2 as the primary statute sort of telling the property appraiser what to do here. And given that fee timeshare real property is only timeshare interests sold as fee interests in real property, when you come down all the way down to 192.037.11 and you see the word, start with 10, 193.037.10, and it talks about resale, and 192.037.11 talking about original purchase price, how can those terms be referring to anything other than sales of the fee interest in the real property, which is much different from sales of beneficial units in a land trust?
I think those are fee interests, the beneficial interest in the land trust.
Is there a definition of the statute that says a beneficial interest in a trust is a fee interest in real property?
I candidly didn't research that or prepare for that in the course of this. It wasn't in the briefing, to be quite honest with you. I believe the trust speaks to that, and it's in evidence.
Well, let me ask, I'll ask you the same question I asked Ms. Purdy then. If, assuming that we did adopt their interpretation and the original purchase price refers to the unit weeks and not to the beneficial interests in the trust, why couldn't the property appraiser say, all right, we start with the original purchase price, we back out the costs that 03711 tells us to back out, and then we go through the exercise of 193.00011 and apply the 8 considerations and reach a conclusion that, even though this original purchase happened some years ago, the best information we have today, January 1st, is still that original purchase price. Why isn't that a constitutional application of all these statutes?
Your Honor, I think it becomes unworkable when you get more and more years out. How are you going to arrive at just value when you're 15 years out, 20 years out, 25 years out?
Doesn't it sound like an as-applied challenge? You
Again,
can say, like, imagine, that you're in 2008 and the sales, let's assume they stopped in 2007, whatever year they stopped. And you would say, yeah, there's no resale value yet. The best estimate we have of the market value is what it sold for just last year when it was still up on the market, right? Now you could say the year 2500, that's not a good estimate. But doesn't that sound like an as-applied challenge?
I don't think so, Your Honor, because I think the statute should be interpreted consistently with the Constitution and with the entire act, as I've already explained. And then you get to a
But let me ask my
constitutional
question.
outcome.
If you're saying that it's not constitutional because it's not a good estimate of value, doesn't that depend on whether it's a good estimate of value in your particular case? Like for the
statute, the way they interpret the statute is not designed and not consistent with arriving at just value. The fact that you could come up with some conceivable way to do it
Well, let me ask you this.
it doesn't mean that it's
Say the last
that's
unit is
correct.
sold September 8th, 2007, and you're looking for a valuation January 1st, 2008. Is it, does the legislature not say, hey, it's reasonable to look at the sale that happened 3 months ago?
That would also be a professionally accepted appraisal practice that makes sense, because you would have a sale, a comp.
Well, you don't have
Timely.
any resales yet, right? Because it was still, there'd be no
Sure.
resale market, because it's not a resale, it's the first sale, right? So that
Agreed.
you'd have no resale, so you'd go to the original purchase price,
Sure.
right? And that's only 3 months ago. Is that not a reasonable way for the legislature to get at just value?
For that, in your particular example, as it works out that the valuation date is 3 months after the sale,
Yeah.
sure. When we're
So
10 years down the road, it doesn't work anymore.
So when a statute
So-
is constitutional in one circumstance, 2008, and unconstitutional in a different circumstance, 2500, Normally, you have to bring an as-applied challenge and say, even though there's circumstances in which this would have been constitutional, it's not in this reason for this instance, right?
I'm sorry to sound like a broken record, but what we're talking about here is developer sales. In your example, you used a developer sale that was 3 months before the valuation date, perfectly legitimate, and that's what the property appraiser would have done. When we're getting 15 years out or what have you, the property appraiser is going to use developer sales, as in this case, in 2017, the year before the valuation date, the calendar year before it. To say then, well, we're going to go all the way back doesn't make sense, and it wouldn't result in a constitutional outcome. So what we're saying to you is what's really meant here, and there's two different ways you can read it, and I do want to address that. First of all, I'd like to say also the argument about fee, timeshare, real property, and the definition, none of that was raised below by the appellants. None of that was argued to the trial court. None of it was asserted, so I think there's a real preservation issue there on that, and that's why I'm not prepared to discuss it.
We still
because
have to interpret the statute and decide whether they're right or you're right. And I think I'm free to look at the rest of the statute and doing that.
As I said, I think the panel has authority to do what it decides to do here. I said that earlier, but I did want to point that out. Can I finish with him? So there's two ways to do this. One, we submit that what was meant by the legislature, or when you apply the doctrines that I've submitted to you that are in our brief, that what we're really talking about here is subsection 10 is developer sales, and subsection 11 is resales owner to owner. Not tied to something that happened 15 years ago. That's what the legislature meant, as said in Scalia and Garner. It needs to make sense, and it's based on a realistic assessment of what the legislature ought to have meant. That's the related statutes canon. I do want to point out there is another conclusion that you can reach and preserve the statute that was reached by the trial court in its judgment. And that is this: everybody agrees that there's two markets. There's a developer sale market and a resale market, okay, for valuing properties, sometimes called the secondary market. If under subsection 11, the only thing that the property appraiser can use is the original sale back in 1999, 2000, what have you, then by definition, what the developer sales that happen after that are resales, because that's what they would be. And the evidence was very clear, and it's in their 10K, that's why one of the reasons the resale market never develops here, an owner-to-owner resale market, is the developer is always taking them back and reselling them, taking them back and reselling them.
If you assume that the legislature is looking at this and saying the developer resale markets, which are like 90% of the resales is the developer helping people resale, are never arm's length, right? Because the developers like fix the prices, they won't let people lower the prices, they bundle it with other products, they restrict the customer base, right? So, a trial judge could find, hey, that's just not a viable resale market, right?
Which is what happened here.
Because while it is a resale market, it's not arm's length or fair market by any stretch, right?
Yes.
In that case, if you go to the original purchase price, even if you assume their interpretation of the statute, wouldn't that actually be the legislature saving property appraisers and getting a higher value? What I mean by that is, it seems like at least one possible outcome is that if there was a legitimate fair market resale value, the value would be zero. Nobody wants to buy these things, right? And so if you didn't back into the original purchase price, and you actually were, if there actually was a resale market that developed in an arm's length way that we could look at, the property is zero. The property is worth nothing. Isn't this original purchase price, even under their interpretation, potentially like saving your side or to your client's benefit?
I respectfully disagree, Your Honor. The property is not worth zero. The developer takes them back repeatedly and resells them for full value all the time.
But
all the time.
The developer doesn't do that in arm's length circumstances, or at least there's evidence of that courts could find.
No, they absolutely do.
Yeah.
Yes, their take back of the timeshare interest is not arm's length. But when they put it back out on the market, in this case, they put it in their trust and they sell it to the public, those are arm's length transactions.
Almost all of the units sold were people also buying other things, that they don't allow sellers to lower the price? If the seller cannot voluntarily lower the price, that's not an arm's length transaction, right?
Respectfully, I think you're conflating two different issues. Okay. What you're talking about is MRHC brokering resales.
Yeah.
Okay? And yes, everything you said about that is correct, and that's what the evidence showed. What I am talking about is not an MRHC brokered resale. I am talking about the developer, as stated in the 10K, Marriott Vacations Resorts or Clubs 10K, they use this ability to take this inventory back and take ownership of it, not through a brokered sale, they just take it back because the person wants out. Developer says, thank you, I'll take it back from you for nothing or for very little. And then the developer resells that again in the developer market. So that's my point. It's not worth nothing. It's when it's put into the proper.
Hold up. The way you determine fair market value is arm's length transaction between buyer and seller, both unable to take advantage of
Yes.
the other and not in a hard circumstance. So you did, in the example you just gave, the seller gives it up for nothing,
Agreed.
right? So obviously they didn't feel they had the market power to gain any money from it. And buying it is not buying it because they're buying it through they're buying it through the developer, which all the evidence is that it's not just simply bought, it's bundled with other things, right? So neither side of those is a buyer buying just that product without any, other confounding factors. And the seller isn't getting any money for it at all. My point is, we don't have an example of actual, just arm's length transactions. Couldn't this be the legislature's way of saving property appraisers from having zero valuations and all
I
that?
just respectfully disagree, Your Honor. Again, the developer is reselling this product all the time for full value. And that's what they use to value the property.
And they're able to buy it at zero regularly.
Yeah, or they can develop it, what have you. But the fact that they get it for nothing doesn't mean that when they resell it, that's not an arm's length transaction. It doesn't, the two things are unrelated. The developer takes it back and they sell it for full value. They're a willing seller, and the people who come and buy it are a willing buyer. So that's an arm's length transaction. In fact, that's what the court actually ruled based on the evidence that was heard. But I see I have 10 seconds to finish. The point I wanted to make is, again, if only under subsection, may I have some additional, are you
I'm
going to
so
ask me
sorry.
more questions? Or, I'm sorry.
We will, we're going to give you a little more time.
Oh, I appreciate it, so I didn't want to rush really fast.
No, I
Sorry.
apologize for
No,
this
that's totally
conversation.
okay. Thank you. The point I want to make, and then I'll answer any questions, is if the only transactions under subsection 11 are the first round of sales by the developer, okay, then when all the other sales that the property appraiser used to value the property fall under subsection 10, because it's a resale of that product. It's just a developer to owner resale of the product, not an owner to owner resale of the product. And so the statute does not say resales owner to owner, shall first look to the resale market owner to owner. It says shall first look to the resale market. So there is no question, and the evidence was 100% undisputed, and the trial court found it, that the developer is reselling this product after it takes it back. So if you want to say that those sales, the sales of the beneficial interest of the trust, aren't the original purchase price, then they're resales. And they fall under subsection 10, and the property appraiser properly valued the property under subsection 10. We in fact argued that at the trial court. The trial court reached that ruling as a backup conclusion in its judgment, and we briefed it. So that's all fully reserved in another way to resolve this in a way that the statute's constitutional.
I have a question. It's my understanding that the original purchase prices of the 46,000 units is not in evidence in this case. Is that correct?
With one exception. Mr. Spaltoff, the corporate representative, I think gave some testimony about what he paid for his back in the 90s.
For one of them, okay.
For one, that's right.
So I guess what I'm getting at is your argument about the potential unconstitutionality of Marriott's interpretation is that it won't produce a just value because the original purchase price was so long ago. But do we have to assume that? Without having evidence of what that original purchase price minus statutory expenses is, to compare it to what the other testimony is about valuation, without that means of comparison, how do we conclude as we sit here that would necessarily be an unjust valuation? What if it's close? Wouldn't it have to be significantly higher or significantly lower than some other method to even advance the argument that it was not a just valuation?
The best answer I can give to that, Your Honor, is first of all, you're right. There's not enough evidence in the record to do those calculations and say it was so much lower back then, other than you could look at what Mr. Spaltoff was. And by the way, there was testimony about basically how the property appraiser's valuation was consistent he actually came out okay when you did the math on his. But at any rate, I just took myself off of my thought process. Here's what I wanted to say. Your Honor, I'd submit to you that built into all of this is professionally accepted appraisal practices. And to answer what you're probably thinking, if you were to ask me, well, did somebody come in and raise their right hand and say using a property 10 years ago or a sale 10 years ago is not a professionally accepted appraisal practice? My answer would be no. But I would tell you that any appraiser would tell you you don't go back 5 years, 10 years, 15 years when you're looking for comparable sales. It's just not done in the appraisal world. And so, in fact, property appraiser having to go find all those deeds and what have you, even if you could do that as a professionally accepted appraisal practice, amazing challenge. And I would submit to you, it wouldn't be a professionally accepted appraisal practice, and then you would be running a tremendous risk of not arriving at just value using that methodology. And it just wouldn't make sense for the legislature to compel the property appraiser to do that. That's the best answer I can give you based on the evidence in the record. Thank you.
Thank you, counsel. I'm going to add some time on to your colleagues
Fair.
on her rebuttal, of course.
Even if it wasn't fair, it's your cost. Thank you. We would ask that you affirm the judgment.
Thank you, counsel. All right, counsel for appellant, I'm going to give you 4 more minutes. Oh, that's the wrong way. Whenever you're ready.
Thank you, Your Honor. So the first point I wanted to make was to direct the court's attention to page 9 of our initial brief, which lays out in total the entirety of 193.011. What I wanted to specifically direct the court to is Judge Ganem's point about how the appraiser is utilizing not only 192.037, but also 193.011, all of the professionally accepted appraisal practices we've heard about today. Subsection 1 says, after applying the sort of presumptive basic formula in subsection 11, if you have to get that far in 192.037, the appraiser is supposed to look to the present cash value of the property. So baked into the scheme is the understanding that the appraiser, in providing the tax bill for the 2018 year, is going to look at the present cash value for this year, even though they're supposed to start by the legislature's directive with the original purchase price and subtracting certain fees and costs of sale. So I think that may resolve part of the court's understandable question about, well, if we start with the original purchase price and there's a large difference in time, if we're in the 2400 scenario that Judge Mize referenced, subsection 1 specifically accounts for considering how it is today to assist the appraiser in preparing a just value. We don't dispute that. If the appraiser in remand below utilizes subsection 11 as they're required to under the plain language of the statute and applies the applicable provisions in subparagraphs 1 through 8 of 193.011, will have a just value. There's not even necessarily as applied facial, any type of constitutional problem, even apart from the fact that it wasn't preserved today. The next point I wanted to raise was one of the last things my colleague on the other side said before sitting down, which was that developer sales are resale. And that's sort of conflating what the MVC trust, land trust is, and what the resale of an deeded week at the Grand Vista is, right? So the MVC Land Trust is beneficial interest in 31 other resorts that have nothing to do with the Grand Vista, might not even be in the same state as the Grand Vista. The statute is clearly contemplating that the resales that you're looking at are the resales of the thing that's being valued, not sales by the developer, what they call the developer sale model in the trial court below, repackaged as resales of the Grand Vista deeded week, because it's just, again, it's not even a comparable timeshare product. It's a completely different product. So I don't think I need to use all 5 minutes of my time, Judge Nardella, but what I want the last points I want to make is, first, there hasn't been an as-applied challenge, a facial challenge, any type of challenge to 192.037. It's not before the court today. There's no basis for the court to affirm the judgment of the trial court on the basis that the statute is unconstitutional. What this court should do at a minimum is remand with directions that the property appraiser follow the plain language of the statute in 192.037. If there is not a sufficient adequate number of resales, to start with the original purchase price, subtract the fees and costs as provided in subsection 11, and then consider the subsections in 193.011 and follow the statute. The statute was enacted in 1988. We have come so far unmoored from the plain language of the statute at this point that the Orange County, where many, if not most, of the timeshares in the state of Florida are located, the people holding those timeshares would greatly benefit from this court's opinion, providing for the first time ever, really, a direction on what the statute means and that the plain language must be followed by the property appraiser. There are no further questions. We ask this court to reverse the judgment of the trial court at a minimum on the failure to follow subsection 11 of 192.037. Thank you.
I want to thank counsel for both parties. This was well argued and well briefed, and this court appreciates it. We will be adjourned. We will come back to talk to those students who have joined us, not about this appeal, but about any general questions they have for our court. The court is adjourned.